The next case is GALE Industries versus Frank J. TRYTEK et al.
Morning, Your Honors.
Morning.
I'd like to reserve 5 minutes for rebuttal, please.
All right.
May it please the Court, my name is Edward Baird, and I represent the appellant GALE Industries in this matter. As the Court knows, this matter got before us today as a result of the trial court's entry of a final judgment in favor of the TRYTEKs based upon a trial that was held in Orange County relative to the reasonable repair charges associated with some electrical repair work at the residence of the TRYTEKs. The trial court erroneously applied a known rule of law relative to who is the prevailing party for purposes of 71329 Florida statutes in the context of the mechanics lien law. For that reason, GALE has filed this appeal. We request that this court reverse the decision of the trial court and declare GALE the prevailing party.
What was the old rule of law?
Sorry, Your Honor?
What was the old rule of law you say the trial judge applied?
The known rule of law, Your Honor. The known rule of law is that when a mechanics lienor recovers pursuant to his lien in any amount, he must be declared the prevailing party for purposes of 71329. And it is error for the trial court to rule otherwise. Now, there's a distinction that we're going to get to, Your Honor, in the context of the net judgment rule. Cases in which a lienor recovers pursuant to an alternate cause of action, such as breach of contract, that's borne out in Prosperity v. Code, which is heavily relied upon by the TRYTEKs, as well as the third DCA's opinion in DCC Constructors, this honorable court's opinion in Michael David Ivey v. Salazar, which is in fact the fifth DCA's most recent opinion on this matter, in which it affirms that principle, that if a lienor recovers in any amount, he must be considered the prevailing party.
Well, but in Ivey, as I remember Ivey, the lien itself was in contest, wasn't it?
It's unclear from the record, Your Honor. The lien itself, there were back charges that were claimed by the owner in that case. And there were a list of deficiencies that were set forth in the opinion. That's correct. But that is not to be confused with turning this case into a single significant issue of being on the counterclaim itself. The distinction is immaterial whether or not the lien is in contest, Your Honor, because the law is clear. If the judgment is rendered in any amount pursuant to the lien, and this is consistent with all of the case law that stands for the proposition that the lien law is intended to benefit the laborer and the materialman supplying improvements to the property, it's consistent with the principle that a lienor has to recover more than is previously offered in settlement from a homeowner. So there's protection for both sides in the context of this framework. But the language from that statute from that opinion is very clear, that if a lienor recovers a judgment in any amount pursuant to the lien itself, then the trial court errs in not determining the lien.
Does it have to be a net judgment in favor of the lienor?
It has to be affirmative recovery in favor of the lienor. Now, net judgment rule is not applicable to this case. I want to be very clear about that. That's discussed in several of the cases cited in the briefs. Prosperity v. Code, the Florida Supreme Court decision. There's the Kenmark v. Cronin case also discusses it.
Hold on a minute. If the counterclaim had been for an amount greater than the amount of the lien,
which it was in this case.
Yeah, but if the court had awarded a larger amount to the counterclaimer,
yes, sir,
than the lien itself, what would your position be?
Then, in that case, if the TRYTEKs had prevailed, recovered affirmatively against GALE in this matter, they would be the prevailing party for 71329. That in Prosperity v. Code, that's contemplated, because in Prosperity v. Code, the lienor recovered zero on the lien due to the submission of fraudulent affidavits over the course of progress payments during the job, and the court expressly stated that had this action been confined to a lien cause of action, there is no question that the owner would have been the prevailing party. However, what the court struggled with in Prosperity was the fact that the net judgment rule was applicable due to the fact that the lienor recovered pursuant to his breach of contract action. The court then gets into this extended discussion solely in the context of the net judgment rule, discussing cases wherein lienors had recovered pursuant to alternate causes of action. And the discussion for the Florida Supreme Court is in the context of the net judgment rule being applicable, originally being intended to do equity as a device of equity between the parties. And the problem and the heartache that the Florida Supreme Court had with that approach is that some of the later cases, as they termed it, applied that rule mechanically or rigidly. So the certified question in Prosperi, the question from the 4th DCA as to whether the significant issues test from Moritz versus Hoyt is applicable pursuant to 713-29 fee awards is answered in the affirmative. But if we look at the reading of the opinion, the concern the court had in Prosperi versus Code was not situations in which a lienor recovers pursuant to his lien. The entire discussion is the context of net judgment rule, and the holding itself even bears that out. That court stated, "We hold that in considering whether to apply the net judgment rule, the trial judge must have the discretion to consider the equities and determine which party has in fact prevailed on the significant issues."
Let me ask you this. Let's change one fact in this situation. Instead of the owner stipulating to partial summary judgment during the course of litigation, let's say on day one they file their answer, and they say, yes, we owe $12,725 under the contract, but we have these construction defects. So they bring their counterclaim. Now you litigate for 4 years, and there's not one bit of litigation about the lien issue because they've admitted in their answer right from the start that it's a valid lien, complies with the lien law, $12,725 is owed under the contract. You litigate for 4 years, and the trial judge determines that $11,000 is owed on the counterclaim. What's the rationale as to why your client should recover for those 4 years of litigation on an issue that arguably they lost?
This argument is partially contained within the TRYTEK's brief, as I understand it, Your Honor. It's contemplated within their argument and within mine for the purpose that a homeowner, if you accept the TRYTEK's rationale and argument as true, that the sole significant issue in this case was the back charges and the counterclaim, then any homeowner facing a construction lien foreclosure could right at the outset in its answer stipulate to the procedural sufficiency and validity of the lien, form requirements, notice requirements, timing requirements, things of that nature. What they would attempt to do in that situation is take the lien out of play. You can't convert a case to a single significant issue case involving only the counterclaim. In that situation, Your Honor, the lienor would have no foreclosable interest unless and until the determination of the back charges. In this case, GALE had no foreclosable lien nor means to recover on the bond posted by the TRYTEK to remove the lien from the property. So that is a necessary determination. The value of the back charges is a necessary determination to the significant issue of the validity and extent of the lien. Now, if you accept the TRYTEK's argument, Your Honor, that permits a homeowner to just stipulate up front and take the lien out of play. Then later, after trial, when a court has to determine who the prevailing party is for purposes of 713-29, the court is constrained to a sole significant issue, if that is in fact the test that's going to be applied, of only the counterclaim itself.
Well, how does the owner protect himself then from an award of attorney's fees if they acknowledge the lien is valid, they acknowledge that all the that there's certain monies owed under the contract, but there's no doubt that there's some construction defects, but the dispute is just, how much are the deficiencies?
There's a line of cases partially addressed in the briefs, as well as in the context of 713 generally, Your Honor, that a lienor has to recover affirmatively. But in addition to that, the lienor has to recover more than was previously offered in settlement by the owner in order to be determined the prevailing party for 713-29. So it can't just be $1. It can be if there's no settlement offer. But it can be $5, or it can be $5 more than was previously offered. So that's the protection to the homeowner, Your Honor. They have the opportunity to make a settlement offer up front, and if the lienor doesn't beat that and still recover affirmatively on the mechanics lien itself, then he can't be the prevailing party. So that's the protection to the homeowner.
Mr. Baird,
Sir.
In Prosperi, there were 2 certified questions that the Supreme Court was asked to answer.
That's correct.
The first question I'm not going to address, but the court said because of the way we addressed this case, we can't figure out what the answer is. But the second question was this: does the test of Moritz versus Hoyt, that's the significant issues test, does the test of Moritz versus Hoyt for determining who is the prevailing party for the purposes of awarding attorney's fees apply to fees awarded under Section 713-29? The Supreme Court was asked in Prosperi if Moritz versus Hoyt applied to construction lien cases. And their answer is, we answer the second certified question in the affirmative. How do you address the acknowledgement by the Supreme Court that Lawrence versus Hoyt applies to 713.29 fees. Significant issues.
Lawrence versus Hoyt does apply to 713.29 fees, but not when the lienor recovers pursuant to the lien. This court can rule.
It doesn't say it.
The court's entire discussion leading up to the holding, Your Honor, is all in the context of net judgment rule. There's not one case that the court is concerned with or even addresses or acknowledges in Prosperi versus Code that involves a lienor recovering pursuant to the lien itself. They are all net judgment cases where a lienor recovers pursuant to an alternate cause of action. And the court actually disapproves of the cases expressly that apply the net judgment rule that is defined within the opinion. They disapprove of that rigid approach, and they use significant issues when in conjunction with the net judgment rule. This court can rule in accordance with GALE and determine that the prevailing party being completely consistent and in compliance with the Florida Supreme Court's decision in Prosperi versus Code, because the significant issues test does not apply, it does not come into play unless and until a contractor fails to recover on the lien but has affirmative recovery or a net judgment on some alternate cause of action.
So you think it makes no difference if the lien itself is hotly contested or not?
That's correct. That's correct, Your Honor. As I said, you don't have a significant issues test solely based on a counterclaim. You have very clear law that came from this court. Your Honor concurred in Ivey versus Salazar that when a lienor recovers a judgment in any amount.
It wasn't me, it was my son.
I apologize, Your Honor. So for familial purposes, when the Orfinkers maybe collectively concurred.
His son actually looks older than him. So
It's a mistake commonly made.
So this court took the language from DCC constructors from the 3rd DCA of 2003. When a judgment is recovered in any amount. This court didn't just cut and paste that language into the opinion in Ivey versus Salazar. It added its own emphasis to the word any. When a lienor recovers a judgment in any amount. So there was some thought given to that principle. So the answer to your Honor's question is no, it doesn't make a difference in that situation. As I said, Ivey versus Salazar is this court's most recent opinion on this matter. It's instructive in controlling upon this court. This court can rule in compliance with Prosperi versus Code. Significant issues test does not come into play unless and until you have a net judgment rule as an issue. For that reason, Your Honors, we're requesting that this court reverse the decision of the trial court and remand for the determination of award of attorney's fees to GALE as the prevailing party.
Thank you, Your Honor. May it please the Court. My name is Michael DeLugo, and I represent the TRYTEKs in this matter. The TRYTEKs were found to be the prevailing party below, based upon what I think is an absolutely correct analysis by the trial judge. And I do not believe that the appellant's GALE Industries in this case can demonstrate that the trial judge abused his discretion in reaching the conclusion that he did. And that is the standard that the court should apply to this particular case. This all goes back, as both sides are going to argue.
Why would this be an abuse of discretion case? Isn't this a pure legal issue of whether or not he applied the right test?
Well, the court in Prosperi, I believe, stated that the decision of whether or how whom to appoint or anoint as the prevailing party is a matter that is within the discretion of the trial judge.
That's if you're comparing significant issues. First you have to get to whether or not the significant issue test even applies. And I think that's the cusp that we're working through here.
Okay. Well, I guess then there are two distinct issues then that I would submit. If it is purely a question of law, then clearly the court in its position can rule as a de novo issue. As to the factual issue of whether the trial court was correct in appointing, then that would be an abuse of discretion. That's correct. But according to the court in Prosperi, I think that counsel for GALE Industries is applying too restrictive an analysis on the contents of the Prosperi decision. I think it has a wider application than GALE is allowing for.
Has Prosperi been applied to a similar circumstance, that is a construction lien in which the general contractor has received some but not all of the award that he was seeking? Has Prosperi been applied to that by any of the district courts?
As a holding in a case, no. I've not been able to find one specifically where we have the same facts that we have here, where there is a construction lien there is an agreed order.
Well, I don't forget about
Set aside the agreed order that they do recover on the construction lien. There is a counterclaim, and the owner of the property is successful in pursuing the counterclaim in an amount that is less than the amount of the construction lien.
No, the prosperity case actually involved a breach of contract. I mean, the basis of the award was breach of contract.
That's correct, Your
So
Honor.
it could be said that any language dealing with the construction land statute was dictum.
I would agree with that, except for the fact that the question that was certified was very broad and very. I think the correct analysis.
Let me ask you something. You know, in this case, you and the counsel for the landlord agreed that the lien was valid, and so there was a summary judgment entered on the lien. Okay.
Correct.
Now, in any case, what's to prevent an owner from saying, fine, your lien is good, I want to argue only my counterclaim? Wouldn't that be a device by which the owner could always claim attorney's fees?
I don't believe so, Your Honor, because if the owner is not successful in the counterclaim,
Yeah, but suppose he is. I mean,
then he should be the prevailing party.
even if he recovers $10.
Well, no, I think that's an analysis for the trial court to make as to who is the prevailing party. If an owner issues a counterclaim and states a claim, as in this case, for approximately $12,000, and the court says, okay, you are successful in your counterclaim in the amount of $10, then I would say that owner is not a prevailing party.
So it depends on the amount. I mean, it could be $15 or $20 or...
It depends on the facts of the case, and I think that is the discretionary issue that is left with the trial court to make that decision.
In your case, I think the ultimate demand is, what, $18,000?
Well, the original demand, the original invoice was $12,770, and then subsequent to that, there were additional matters that were added as the case went on.
So you got $11,000 something.
$11,250, I believe.
Well, suppose the court had only given you 9 or 8 or 7 or 6.
Then it would be a determination within the trial, the discretion of the trial court to make a determination as to whether the owner was the prevailing party on the significant issues in the case. And I think
Isn't that kind of a very subjective standard?
Absolutely, and there's no definition of prevailing party in the statute. So I think that the legislature did that intentionally.
Well, ultimately, the lien claimant who's sitting there quietly gets his award. I mean, gets his lien verified.
Correct. That's true, but under the circumstances of this case, if that issue is not tried to the trial court, then that it shouldn't enter into the analysis under the language of Moritz and Prosperi applying it to 713-29.
So your position is that it does make a difference that the lien has to be litigated, and when you offer to acknowledge it, he has to say, no, we're going to litigate it.
Well, I think it does make a difference whether it's litigated, because the issue as framed by the Supreme Court is who is the prevailing party on these significant issues tried in the case. And I think that the word tried means what is presented at trial. And that is what is at issue here. The trial court...
Not exactly that. It's who is the prevailing party for purposes of awarding attorney's fees. It doesn't mention significant issues.
From where are you reading?
The question certified from the Supreme Court from Prosperi. Does the test of Moritz for determining who is the prevailing party for purposes of attorney's fees apply to fees awarded under 713-29? It does not say significant issues.
But it's implicit in, does the Moritz test apply? And the Moritz test is the significant issues test. And so I think by citing to Moritz, I think that's what the Supreme Court in Prosperi was stating.
Why should we put the burden on the owner? For instance, Judge Orfinger just asked you, $7,000, $8,000, $9,000, where does the trial judge draw the line? Why don't we put the burden on your client, even though your client's suing for $18,000 counterclaim, if you reasonably think you're going to get $11,000, why don't you pay them an additional $1,500, $1,700 so that when the result comes out, you're getting money from them instead of them getting money from you? Why shouldn't we apply that test?
Well, I think that would be one option for a party to do. That is not the tactical decision that was made below in this particular case. But I don't know that it makes a difference as to the ultimate outcome, whether you pay someone in 2003 or you pay someone in 2005 or you pay someone in 2007. The legal issue as to the procedural and substantive sufficiency of the mechanics lien that was filed was not an issue at trial because it was agreed upon and it was the subject of an agreed order.
Right, but if they're bringing a claim for $12,700, and you think that you got $11,000 counterclaim, even though you're suing for $18,000, why don't you pay the couple thousand because you know you owe the money anyway?
Because the money will be owed no matter what because we've agreed to the entry of a judgment on the lien. So the mechanical tender of money doesn't make a legal difference because we've already agreed that we owe the money.
And even though you're saying the lien was uncontested, you'd agree that they can't actually foreclose on it until the counterclaim is resolved. So they still have to go through.
That's still an issue.
They still have to go through that litigation to foreclose on that lien.
That is correct, but their entitlement to the funds subject to the counterclaim is not being contested.
All right. Before the trial judge made the attorney's fee award, they had a judgment which they could foreclose on. So in other words, they have
subject to the counterclaim.
Okay. Did your client file a notice of contest of lien?
I'm sorry, Your Honor, I don't know the answer to that. All I know is that there was the
Would that have made any difference?
I don't believe so because, again, going back to the language of Prosperi and further back into Moritz, the issue is what are the issues at a trial. And so I think that by entering into an agreed order on the motion for summary judgment on the lienor's part, that takes that out of play.
Well, here's the problem with the agreed order. The agreed order says we agree that you followed all of the procedural requirements of the statute. It doesn't say we agree that we owe you $18,000.
Because we didn't agree that we owed them $18,000 or $12,000.
So I guess what my point is, does that agreed order actually take the construction lien out of play?
Yes, Your Honor, it does.
I think all it takes out of play is the procedural parts. That is, I filed timely, gave the correct notices, and served everything.
No, Your Honor, I disagree. I think it amounts to an agreement that we owe the lien holder $12,700 or whatever the exact number was, subject to our counterclaim, so that we ultimately will owe you $12,700 minus whatever we are found to have reasonably expended in fixing the defects that they in fact caused originally.
So what you've saved them the trouble of doing by entering into the stipulation was you've saved them the trouble of proving up the procedural aspects and proving up the amount of their claim.
Yes.
And still in contest was the amount of your counterclaim.
That is correct.
I need to follow up on a question I asked you earlier. In the context of your case, you remember I asked you what the difference would be if your counterclaim had resulted in an award, say, of $5,000.
Yes, Your Honor.
And you said it was up to the discretion of the trial court then to determine who the prevailing party was.
Correct.
So under that scenario, the trial judge could have determined that the lien claimant was the prevailing party and awarded attorney's fees against you.
That is correct.
Okay.
But I'm suggesting as a factual matter, this goes back to the legal issue versus the factual issue. As for the factual issue, that the court found that we were the prevailing party below, and that issue or that determination is subject to the abuse of discretion standards. Sorry, Your Honor, did you have a follow-up question?
Yeah, what do we do with all the cases that we have in our history that say if you collect $5 on your lien, you're entitled to attorney's fees?
Well, it's interesting. In looking through these cases, and I want to choose the Ivy case because the GALE Industries relies on that quite heavily, and that is the most recent, I believe, decision from this court on this issue. The Ivy court quoted DCC constructors and said if a lien holder collects any amount on the lien, then they are the prevailing party. But then later in the paragraph, they quote from Prosperi and talk about the significant issues test.
It's confusing. I agree.
So I think that the appropriate thing to do is to try to clarify what exactly, how these two are in tension with one another, and I think that needs to be clarified. And I think the trial judge recognized that below. I think the order that is the subject of this appeal, the trial court said that he was struggling with the two competing arguments on this particular issue. And I think as a matter of equity in applying or in addressing the issue here, I think what you've got is you've got GALE Industries that committed wrong in doing the installation that they performed, and they should not, after committing the wrong in the first place, be able to collect attorney's fees for litigating that issue for 4 years. I think as an equitable matter, this case requires a decision that affirms the trial court just based on the facts that gave rise to the original litigation.
Assuming that I don't necessarily disagree that we've sent out conflicting signals to the trial court, should we send out a signal to them saying, look, in this situation, if the homeowner recovers a judgment less than the amount of the lien, we're going to give you all sorts of discretion on figuring out, not much guidance, in figuring out who's the prevailing party? Or should we say, look, why don't we set the amount, whoever gets $1 is the prevailing party, and the homeowner needs to determine how much is the likely result and pay that money or offer to pay that difference.
And the way I interpret your question is should there be a black and white rule or should there be a flexible rule? And I would advocate that the Supreme Court has already stated that the rule needs to be flexible and that the discretion needs to reside with the trial court in order to make that decision. I don't think there used to be a black and white rule on the net judgment rule, and in fact
the question is, does it still exist?
I don't believe so. I don't believe so. I think that the prosperity opinion stands for the proposition, and adopting and Moore's decision prior to that stands for the proposition that this is a flexible issue that the court needs to have, or the trial court needs to have the discretion to be able to say who is the prevailing party. And to reach that conclusion, they have to analyze who succeeded or who prevailed on the significant issues that were tried in the case, and that is simply within the trial court.
Wasn't prosperity correct in a situation where someone might bring 4 counts and they won on one count, lost on another, won on a third, lost on the fourth, and the judge had to make the decision, and beforehand you just, if say 2 of those 4 counts had attorney's fees, the judge gave attorney's fees on those counts only, regardless of the overall outcome in the case.
That's correct.
And this is different. This is really one outcome.
Does the offer of judgment rule apply to construction lien cases?
I believe it does.
Well, why wouldn't it make sense for us just to say, look, if a homeowner feels, or the property owner feels like the general contractor is entitled to, or the lienor is entitled to an amount, but not the amount that they are claiming, why wouldn't the offer of judgment rule offer the homeowner an opportunity to avoid those fees by simply agreeing to pay a judgment less than the full amount?
It would, but I don't think that forecloses the means by which this case was litigated. I don't think that the existence of 768-79 means that that's the only mechanism that a homeowner has at its disposal. It is a mechanism at its disposal in order to preserve a right for attorney's fees, but based on the language of 713.29 and the judicial interpretation of that statute over the years, I think that a homeowner is certainly within its rights to assume that it can pursue its counterclaim, virtually eviscerate the mechanics lien that was put in place and agreed to, and expect to be found to be the prevailing party.
I think what we need to say is mediate.
I could not agree with you more, Your Honor. I don't have anything further. If the Court has any further questions, I'd be happy to answer them, but otherwise I will sit down.
That's fine. Actually, since the two of you speak so rapidly, we surely limit you to 15 minutes anyway. You got 20 minutes worth of words.
I apologize, Your Honor. I've been accused of that for many years. Please, Court, Your Honor, just a few brief points for rebuttal. The net judgment rule does, in fact, still exist, Your Honor. It's simply not applicable in this case. The net judgment rule is spelled out very clearly as to what it envisions and when it applies in the Prosperi case and Kenmark v. Cronin and others cited within the briefs. The net judgment rule is absolutely inapplicable to the case at hand due to the fact that GALE recovered pursuant to its construction lien in the case. The framework for the judgment in any amount test, as enunciated by the Court, is applicable and makes sense due to the fact that the owner has the opportunity to make an offer for what it believes to be the appropriate set-off prior to litigation.
Ivy does include the Prosperi language, as we discussed earlier, Your Honor. The Prosperi reasoning and concern the court has is simply inapplicable to the facts below. This court can feel free to rule in favor of GALE and complete consistency with the Supreme Court in Prosperi versus Code. This court, for instance, in fact, has rejected the very argument that the significant issues test applies in Ivy versus Salazar.
It's kind of hard to say whether Ivy actually does.
I'm sorry, Your Honor?
It's kind of hard to say whether Ivy actually does that.
Well, the Salazars contend in their brief that they are the sole prevailing party based upon the significant issues test as enunciated in Prosperi. This court then has language for the judgment in any amount test.
But in Ivy, the construction land itself was litigated.
It wasn't. It was, absolutely.
And so it's hard to rationalize that case with this one.
But the facts are strikingly similar, Your Honor, where the lienor files a claim of lien. We go through litigation, and the owner is awarded a substantial set-off before an award to the contractor. Again, the cases don't say that the contractor has to get everything he was seeking in order to be the prevailing party for purposes of a mechanics lien action. He just has to get A, more than $1 or $1 or more, and B, more than was previously offered by the owner.
Counsel, do you know of any cases in which any of the district courts have said Prosperi applies to construction lien cases?
I do. This court said so in Corley versus Rivertown a year prior to Ivy versus Salazar. Corley versus Rivertown does apply the significant issues test in a situation in which a construction lien prevails on claim of lien. However, as I said, a year later, this court came down, Michael David Ivy versus Salazar, same set of facts, or a very similar set of facts, where a lien prevails on the lien itself, and again, stressed that judgment in any amount language from DCC out of the third from 2003.
Well, but in Corley, we said it's clear that, after citing Prosperi, that it says it's clear from the record that the construction lien was the significant issue to be tried, so that doesn't help us too much.
Your Honors, I don't believe the court's going to find any case.
Yeah, I don't think so. I have not.
Where a lienor recovers pursuant to the claim of lien itself and is not declared the prevailing party for 71329. I've looked long and hard for a case that says that. I don't think the court's going to find one. For that reason, we request that you reverse and declare GALE the prevailing party.
Thank you. Very well argued case. Thank you, counsel, for both sides. Ms. Moses, don't be so anxious. We're going to take a quick break, and we'll be going to the coffee room. Please join us there if you would like, and perhaps you can congratulate Judge Orfinger on 112 years of service to the state of Florida. We'll be in recess for a few minutes.